And like I said, we are very happy tonight to have Amy Rhone. She is Office of Special Education Administrator. She's the state director. So tonight we're just going to do an overview and general information about compensatory services and extended school year services, and just give some examples, some thoughts on who you can talk to on your team about these services, and just a disclaimer that we are not able to answer questions about specific situations, but more in general terms is what we'll be able to talk about this evening. If you have any questions about this webinar or any, if you want to get in contact with a PRC, even if you're out of out state, anywhere in the state, you can contact either me or Whitney, and we can get you in contact with somebody to address your needs. And with that, I will turn it over to Amy. Thank you.
All right. Well, I'm going to share my screen in a minute too. So give me a second to, I think. Now, can you see my screen?
Yes.
All right. Well, I am also, I got to find this. I am also going to share a link with everyone. I just put it in the chat where you can have access to the slides that I am about to present on. I've linked some information in the slides, and I'll make sure and point that out as I talk about it. But as Jennifer just so kindly introduced, my name is Amy Rhone, and I am the State Director and Administrator for the Nebraska Department of Education, Office of Special Education. And I'm so excited to be here with you tonight because, as Jennifer mentioned, this is quite a timely topic. And we've been fielding quite a few phone calls in our office about extended school year and compensatory education. So it's a great opportunity for me to just get some global information out there, with the caveat that I may cause more questions for you as you listen to this, but at the end of the slides, I'll share my information so you can reach out if you have any additional questions. But ultimately, you might be wondering if your child with an individualized education program or an IEP can receive special education services during the summer or during breaks. These services are known as extended school year or ESY. And these are options for some students. In 2021, some kids will qualify for compensatory services if, due to the pandemic, the school was unable to provide the services called for within an IEP. This is not the same thing as ESY or extended school year. So tonight we will dig into both extended school year and compensatory education in hopes that we will gain a better understanding of both areas as they may pertain to students with disabilities. As Jennifer mentioned, I'm going to do a quick section on extended school year, and then we'll make sure and check the question and answer function. So if you have any questions as they pop up, don't hesitate, pop them in there. We'll answer some of those, and then we'll go into compensatory education, and we'll go over questions from there. If you have a question about compensatory or extended during either one of those, and it's not that time, go ahead and pop them in there, and we'll make sure that we can get to those as they come up. So let's start with a conversation about a new NDE Office of Special Education Family Guidebook. So I want to point you to the NDE Office of Special Education website at www.education.ne.gov/SPED. The Office of Special Education is excited to announce the newly published Family Guide to Special Education in Nebraska. In partnership with PTI Nebraska, the Family Guide to Special Education in Nebraska describes how parents play an essential role in their child's education. When a child has a disability and needs special education, parents are the child's most powerful advocates. If families believe that their child has a disability and needs special education, it is important to learn more about the special education process. This guide provides a brief overview of Nebraska's special education process. By gaining knowledge and skills, families and parents will be able to participate more effectively in meetings and make more informed decisions for their children. This guide includes questions parents can ask your child's school district staff about special education. At the end of the guide, there is a listing of resources where you can then find more information. Parents and educators can find tip sheets, a screencast, parent-family rights and special education sheets, and parent-family resource sheets that are embedded into the relevant topic areas within the guide. You can also find these same embedded resources on the Parent Rights/Family Information tab of our website at education.ne.gov/SPED. The guide can also be found at pti/nebraska.org. So let's dive into the real reason why you are here, and that is to learn about extended school year, or ESY. The purpose of an extended school year is to prevent or slow severe skill regression caused by an interruption of special education services during extended periods when school is not in session. It is not to enhance the present levels of educational performance exhibited by children with disabilities at the end of the regular school year. The NDE Office of Special Education has specific guidance regarding extended school year that is linked within the slides that I shared. You will be able to click on the photo of the actual guidance document and it will take you straight to the direct link. So just a disclaimer, ESY was not designed to resolve issues created by the pandemic. The need for extended school year services is based on a construct of skill regression and a child's limited capacity for recoupment. An extended school year may be provided only when it is determined that a child might regress in a critical skill area to such an extent that recoupment of the skill loss would require an unusually long period of time to recoup or make it unlikely or impossible to recoup the present level of educational performance. Within the categories marked by a severe disability, it is not appropriate to assume that a significant regression or recoupment factor exists. Some children with severe disabilities may consistently demonstrate a limited array of skills, but not demonstrate a significant regression or recruitment factor in any of those skills. Therefore, these children would not be appropriate candidates for ESY services. As your team makes ESY decisions, remember that ESY is not required based on a lack of expected progress on IEP goals, particularly considering the school closures and remote learning disruptions impacting all students. Also remember that ESY is different from compensatory education, which we will dive into more later. Also, a huge disclaimer is ESY services are not the same thing as summer school. They're specialized instruction or related services that are part of the child's IEP. If your child receives ESY services, they are also at no cost to you, and they are under the umbrella of FAPE. Many times we often refer to or say students with disabilities are general education students first. So if the summer school program is offered to general education students, it should be offered to students with disabilities as well, and should not be confused with what ESY services are provided to students. ESY services are provided when school is typically not in session. That's often during the summer, but for some kids, it can also be during an overextended breaks like winter vacation or spring break. The services are individualized to help each child maintain skills and not lose the progress made towards goals. For some kids, this may mean one-on-one tutoring. For others, it may be a few sessions of occupational therapy or speech therapy each week. What ESY looks like for your child is a decision that should be made by the IEP team. ESY is not designed to help students make up for what goals may not have been achieved during the school year or prepare for the school year ahead. The services are available to those eligible to allow the student to retain their knowledge and skill level and prevent them from regressing when school is not in session. So who is eligible for ESY? ESY isn't guaranteed for all students who have IEPs, and not all kids with IEPs need it. The Individuals with Disabilities in Education Act, or IDEA, lets each state or school district set its own rules for eligibility. So the standards vary from place to place. Just like many states, Nebraska's regulation, known as Rule 51, defines ESY to mean special education and related services that are provided to a child with a disability beyond the normal school year of the school year or approved of the school district or approved cooperative, in accordance with the child's IEP, at no cost to the parents of the child, and meet the requirements of 92 NAC 51, which is also known as Rule 51. IDEA does say that schools can't limit ESY services to kids with certain challenges. For example, a school can't decide to not give services to kids with dysgraphia. It also can't give services only to kids with autism spectrum disorder, for instance. So let's review Nebraska's regulation and what it says about ESY. 92 NAC 51, section 007.07C5B states, extended school year or ESY services must be provided only if a child's IEP team determines on an individual basis, in accordance with section 007, that the services are necessary for the provision of a free, appropriate public education. 007.07C5C states, in implementing the requirements of this section, a school district or approved cooperative may not limit extended school year services to a particular category of disability or unilaterally limit the type, amount, or duration of those services. So what exactly does an IEP team consider to figure out if ESY services are needed? If your child is eligible, the IEP team may talk about ESY services. The main issue the team looks at are regression or losing skills and recoupment, the time needed to relearn skills. The questions the team considers are, will your child lose critical skills without continued support and teaching? Will it take a long time for your child to regain those skills? Longer than it would take a child without a learning difference? If your child has a history of regression and struggling to relearn, the IEP team will take that into account. If there's no data, it can be harder to make a decision, but there are some questions the team may ask to help predict how likely your child is to regress. These will include, has your child had difficulty retaining skills over shorter breaks? Does your child have known challenges with working memory? Does your child need continual reinforcement to keep skills during the regular school year? Does your child have behavior challenges that get in the way of learning during the school year? Will that be a problem next year without continued support over the summer? Is your child making steady progress towards meeting IEP goals? And will a break in services threaten that progress? And finally, is your child just beginning to master a critical skill, such as learning to read? So how can kids get help during the summer? Even though not all kids are eligible for ESY services, every IEP team should discuss the option. If you think your child might need ESY, bring it up at your child's next meeting. You might ask the team to get your child's teacher to assess any regression or recoupment issues your child has after the shorter school breaks during the year. It's also helpful to make sure your child is assessed after summer breaks. That can help the team plan for next summer or next winter break. Keep in mind too that ESY isn't the only way to keep kids learning. You can also reinforce your child's IEP goals at home or take advantage of other types of summer learning programs. For more information on extended school year or ESY, check out the Nebraska Department of Education Office of Special Education tip sheet on ESY within the Family Guide to Special Education in Nebraska. If you are accessing the Google Slides, you can click right on the picture of the Family Guide and it will take you directly to the extended school year tip sheet. So before we jump into compensatory education, I'm going to go over and make sure we've addressed any questions you might have. All right. Well, I don't see any, so maybe you're saving them till the end.
I'll just jump in here with one that I got.
Okay.
It says, can you clarify, is the degree of process towards goals a criteria for ESY? Or no, is it just recoupment and regression?
It is just recoupment and regression. So the degree of progress, if the progress isn't being made because a student has a struggle with recouping or retaining that information during extended breaks, even if that break is 3 or 4 days, then that might lead to a team deciding that the progress isn't being made because of recruitment and regression issues. But if it's just that a student isn't making progress, that might not be enough to make an ESY determination.
Thank you. I don't have any other questions that came to me.
Okay. Well, let's now move on to compensatory education, or Comp Ed as it's commonly referred to. Oh, I see one just jumped in. It says, what type of assessments after breaks are recommended? So these can be as simple as having your teacher do some time on tasks, or it could be even more detailed, asking your IEP team to do some evaluations around information that was taught, and it appeared that the student retained the information before going on break and then after going on break, such as spring break. We're coming upon that time. I know my son's on spring break right now. Some of the information that was taught prior to spring break, you could do some simple formative or even summative assessments to see if they've gained or kept those skills and knowledge after the break to see if they've retained it.
And then it looks like we have one more. Does ESY apply in a transitional program or just K through 12?
So that's a great question. In a transition program, I'm assuming this to mean an 18 to 21-year-old program. It would completely depend on the student and what the student, of course, because ESY would be an individualized basis. But if in that transition program, the student is continuing to learn skills or gain knowledge, it would be the same measure for any student, not just in a K-12 program, but any student ages 3 through 21 in Nebraska.
Got one more. If a parent requests this from teachers, and the school does not document any regression or recoupment as requested, what would you advise a parent to do in that situation?
So I would advise, and we'll get into this at the end when I talk about some of your next steps in this process, if you don't feel like your voice is being heard in some of these decisions. But I would first advise that you ask for an IEP meeting so that you can call the team together and voice your concerns or talk about what that looks like. But if that doesn't get you where you need to, and I'm going to go over some of your remedies around solving disputes as they come up in IEP teams.
Okay, and then just the last question was, does this also apply to students who attend BEST?
So I'm going to reshape the question a little bit. So it would be, does this apply to students who attend a level 3 program or an alternative school setting? Because BEST is a a program that students attend? And the answer is yes. Individualized education plans or programs, IEPs, have to be followed regardless of the setting. The resident school district or the public school is responsible for writing the IEP. How those IEP services are delivered are up to the school to make sure that wherever the student is receiving those is following that. So if the IEP determines that ESY is needed, that would fall back on the school to provide. So it might not happen in that same placement. It might not look the same. It might not be best services or a level 3 or alternate educational program services, but the IEP team would need to determine that. All right, I think, should I move on?
Yep, that was all the questions.
Okay, so let's move on to compensatory education, or Comp Ed, as it's commonly referred. Compensatory education services are not expressly defined in the federal law. However, courts under the federal law have long awarded compensatory educational services as an appropriate remedy under the law when a student has been denied a FAPE. In the present circumstances, the purpose of compensatory educational services is to remedy the district's inability to provide a child with a disability with appropriate services during the time that the child is or was entitled to a free, appropriate public education. Compensatory education is designed to put a student in the place they would have been had the student not been deprived of special education and related services. Compensatory education means that the student with an individualized education program or an IEP, as it's known, or a 504 plan receives makeup services. Comp Ed are services a student is entitled to if it is found that the school has not been providing a free and appropriate public education. If the school does not provide services in the IEP or 504 plan or denies services to which the student is entitled, it may be violating the requirements of FAPE. Your child may be entitled to compensatory education services if services in the IEP are not being delivered. And for example, or an example would be the student's IEP states that he should be receiving 2 hours a week of physical therapy or some type of assistive technology, and it does not provide that service or that device. It also states that services in the IEP are provided, but not as directed in the IEP. So an example of this might be the student is supposed to be getting 3 hours a week of speech therapy, but has only been receiving 30 minutes a week. Parents requested that the student work with a reading specialist, but the school denies the request. But it's later found, perhaps by a private evaluation or through a due process hearing or complaint, that the student was entitled to that service. Comp Ed may be in order. So why is this such a big deal right now? Well, with COVID-19 school closures and the movement to temporary remote learning, this may have caused the loss of special education services or kept some students from making adequate progress on their IEP goals. That may entitle them to compensatory education. So why might compensatory education services be required as a result of COVID-19 related school closures or suspension of in-person instruction? So in addition to the traditional use of the term compensatory education services to describe services required to remedy a violation of IDEA that resulted in a denial of FAPE, this term is also used by the U.S. Department of Education to describe services that may be required to remedy the loss of skills and regression as a result of extended school closure and disruptions to in-person instruction, circumstances caused by the pandemic that are beyond the control of schools. So I have linked the questions and answers on providing services to children with disabilities during the coronavirus 2019 outbreak that was released by OSEP, which is the Office of Special Education Programs, last March, that directly speaks to that. To directly quote the guidance, during this unprecedented national emergency, schools must prioritize above all else the safety of students, staff, and communities. Consistent with this priority, schools must also ensure that, to the greatest extent practicable, students with disabilities are provided the special education and related services identified on the IEP. Because FAPE must now be provided consistent with the need to protect health and safety, there may be disruptions, delays, and or challenges in how services are provided, resulting in a student losing skills. Schools must therefore make an individualized determination whether and to what extent compensatory education services may be needed to make up for any skills that may have been lost as a result of COVID-related disruptions to the provision of FAPE. So what this means is that there may have been situations during remote learning or school closures where the IEP wasn't followed. We've had almost a year now where schools have been back in session and trying to renew and accelerate the learning of our students. During this time, there have been great attempts to make up some of the learning loss that was typically found to be normal for all students, including our students with disabilities during the pandemic. However, if you feel like there were times that your child's IEP was not followed, you should absolutely ask for an IEP meeting to consider compensatory education. So where can you find information on compensatory education in the law? Well, you may have heard me mention in the first slide about Comp Ed that compensatory education services are actually not included in the Individuals with Disabilities Education Act, or IDEA, nor in the Rehabilitation Act pertaining to 504s. IDEA does, however, authorize the court to grant such relief as it determines appropriate. In fact, IDEA says it authorizes the court to grant such relief as the court determines appropriate. And as you can see from the previous guidance document that I shared, the idea that districts are making determinations around compensatory education is clearly articulated. However, it is not presumed that all students on IEPs will need compensatory education. Rather, it is expressed over and over again that these are determinations that should reflect the I in IDEA, which is individualized. So let's say that your IEP team has decided that your individualized student is entitled to compensatory education. Now you are probably wondering, how is that Comp Ed going to be delivered? Comp Ed is usually provided outside of the regular school day. It could be provided before or after school, over the summer, and or on weekends. Compensatory education during the summer is not the same as extended school year, or ESY. Your child may need and be entitled to both. The other big key point about compensatory education is that it cannot be something that takes the place of your child's current education. So it does have to be in addition to the education that is currently happening. Depending on what the parents and school agree to, or what is ordered by a hearing officer or complaint investigator, Comp Ed services may be provided by school staff or by a private provider or program. So if you're denied Comp Ed, you can access dispute resolution mechanisms that I will discuss in just a moment. So let's first talk about how is the amount of compensatory education determined. Figuring out how much Comp Ed is due to a student can be complicated. If it is a due process hearing issue, the hearing officer will calculate the amount based on his or her judgment after hearing testimony. If it is a settlement agreement, the school and parent attorneys will negotiate what will be provided. And if it is awarded as part of a state complaint, you may have an opportunity to come together as an IEP team and make this determination, or it may be calculated for you. In most situations, if an IEP team determines that compensatory education is needed, that team is the one responsible for determining exactly how many minutes or hours of compensatory education a student may need. In any of those 4 scenarios, these are the factors to be considered. How long the student was denied FAPE, either an IDEA FAPE or a 504 FAPE. Is the Comp Ed reasonably calculated to provide the educational benefit that the student should have received had the services been provided as they should? What were the negative effects of not receiving services, and what specific services are needed to make up for those impacts? What level of services does the student need to catch up to where she or he should have been? And finally, it's important to note that most compensatory education is not a minute-for-minute calculation. In fact, all case studies or case law shows that hearing officers or complaint investigators do not award minute-for-minute calculations. So now that we've discussed both of these, you may be wondering, what is the difference between ESY and compensatory education? Well, first of all children with disabilities who have a current IEP must be considered for ESY services at least annually, versus compensatory education services, which is to remedy the district's inability to provide a child with a disability with appropriate services during the time that the child is or was entitled to a free, appropriate public education. We flippantly talk about how hopefully compensatory education services are actually something that's not considered annually, if ever, in a student's IEP lifetime. So another key question that has arisen is, should a school district provide summer school and/or extended school year or ESY services for all students with disabilities as a way to address a potential need for compensatory education services resulting from COVID-19 related closures or suspension of in-person learning? The answer is no. Compensatory education services and ESY services are not interchangeable, and a particular student may be entitled to one, both, or neither, depending on the individual circumstances. Although appropriate and effective ESY services may help a student maintain skills, schools must ensure that individualized determinations are made for ESY eligibility services and compensatory education services. Schools should not create blanket rules offering ESY to all students. So after all of this, you are thinking, so now what? If you think that your child needs additional support because of regression or recoupment, or that they are denied, that they were or are being denied services at any point, my first suggestion is schedule an IEP meeting. Scheduling an IEP meeting to discuss your child's present levels of performance. Present levels is a term used in the IEP document that means exactly what it says. It is documentation of how your child is doing right now. Your child's present level of performance may be different now from what it was before learning remotely. You and the IEP team should consider what information you have about how your child is doing and whether your child needs any tests or assessment, formal or informal, to determine where they are after a year at home. When it comes to the present levels of performance, what information do you already have? You are the expert on your child. I say this all the time. However, during school at home or remote learning, you were also your child's teacher, administrator, and tutor. Many parents are reporting that they know a whole lot more about their child as a learner than they did before remote learning. You need to share what you know with the IEP team and make sure they hear you. Make certain that the data you provide is recorded in the IEP or the prior written notice document. Some teams may tell you that your data is only from home or doesn't hold as much weight. That's just not true. Insist that they include any data you have in written documentation. If it's not written down, it didn't happen. If you see a weakness that wasn't previously identified, that weakness should be explored. Share data, notes you kept, work samples, and your experiences with your child during the time that reflects academic struggles and possible regression due to loss of instruction and supports. Ask for new assessments if you think they are needed, and don't take no for an answer. You are an equal member of the team. Oops. And last but not least, know your procedural safeguards and parent rights when it comes to your child. There are 4 dispute resolution options available in Nebraska, and we want to ensure that everyone is aware of each of these options in order to reach out in a timely manner to resolve issues as they arise instead of letting them compound over months or even years. Anyone can suggest utilizing these options, and we encourage families and districts to seek help in resolving issues early on in order to maintain positive relationships with each other and in an attempt to not wait to fail with your child. The first option that you'll see at the top of this table is IEP facilitation. It's where a neutral party is invited to the IEP team meeting to act as a facilitator to the conversation. They are not decision makers. Instead, they offer support to guide the conversation when the district and the family may not see eye to eye on particular issues. It is completely voluntary for both parties and can be extremely helpful to seek the support when issues begin to arise that could cause conflict. IEP facilitators can be requested through your district or by going to the State Department of Education's website. On the Google Slides, by clicking on the picture, it will take you directly to the dispute resolution page. The second option in the table is mediation. It is also voluntary for both parties. In Nebraska, we contract with mediation centers across the state to provide a trained mediator to act as a neutral party in order to help parents and districts identify and discuss issues in an effort to maintain a positive relationship between the parties. Often, once in conflict, parties may not be able to identify what the issues are because emotions run high. Mediation offers support to both parties in order to hear their perspectives and help the parties to identify issues and work towards an agreement that is written in the student's best interest. We have noticed that oftentimes when a family or district calls the Office of Special Education with a question, conflict has been going on for quite some time, and frustrations may be running even higher than they need to be. When presented with their dispute resolution options, many people aren't aware that the IEP facilitation or mediation options are even available to them. The last 2 options are the more litigious options and ones that all parties should wish to avoid. However, there are times that a state complaint or a due process might be your option that best fits your needs. A state complaint is a written allegation by an individual or an organization that a school district has not followed special education law within the last calendar year. A complaint must be in writing, tell the facts regarding the allegations, the laws that may have been broken, and a proposed resolution. If the allegations regard a specific child, the child's name, address, and the name of the school attending are needed. A copy of the complaint must be sent to the named school district at the same time as the parent sends it to the Office of Special Education. A part of the state complaint that is also a part of a due process hearing will be set aside until the conclusion of the hearing. Any issue in the state complaint that is not a part of the due process action must be resolved using the time limit and procedures described in Rule 51. A due process is a legal process used by parents and districts to make a decision on issues within a hearing. The hearing officer's decision is final and binding unless appealed. Due process can address issues surrounding evaluation, IEPs, educational placement decisions, and FAPE. A school district may request a due process hearing if a parent refuses to give consent or an initial evaluation, or the district feels it should not pay for an individual education evaluation. When a hearing is initiated, schools must inform parents about the availability of mediation, and any party has the right to be accompanied and advised by legal counsel and individuals with special knowledge or training in special education. Parents may request themselves or use a lawyer to represent them and their child. So I know what I've given you is a lot of information. And as I said at the beginning, I may have added more confusion. So with that, I think I see questions. So I'm going to first answer some questions before I go any further.
Do you see that first question in chat that we had from Shelley?
And my cat has decided to join us. So I'm going to put her down. From Shelley.
So Shelley wanted to know if the funds were handed out, how would they know that they were handed out to their school?
If the funds were handed out.
How do we find out if our district allocated the ARPA funds to children with disabilities? And if so, for what services?
So this isn't in regards to compensatory education or ESY, but all districts in Nebraska received additional IDEA funds specific to the American Rescue Plan. These funds were added to their already existing IDEA grants to provide services and supports to students with disabilities. So there, if you're talking about, and I think just based on the questions, what you're talking about is the ARP funds or American Rescue Plan funds that were provided to districts outside of the IDEA. All districts were required to develop an ESSERS plan, ESSER, that must be available on each district's website. So you can go to your district's website and find their ESSERS plan to see how they will be utilizing the additional American Rescue Plan ESSERS 3 funds. I think I've answered that correctly.
Thank you. And then our next question we have would be, if a goal is written for professional observation, what kind of data should have been kept to monitor progress for an IEP, and how can they get that for themselves? I think what they're asking is how they can see what data the school's actually been using to track their child to see what progress they've made.
Yep. So every quarter or every time that your school sends out normal report cards or grade information, they are also supposed to be sending out progress monitoring or progress notes from the IEP. You can ask as a member, as a parent, and as a member of the IEP team, you can ask to see the data in which they're collecting to determine how that progress is made at any point in time.
Thank you. And I don't actually see any other questions right now. Oh, wait, we got one more. Is there someone in an IEP team that would know this information? Yes, that is, I can kind of help answer that one too. Yes, all of that information should be, like she said, it will be in the file and it's all there for you.
And so as I made mention around ESY, every single year, so you must have an annual IEP meeting, and at each annual IEP meeting, you are to discuss, every single student with a disability is to discuss the need for extended school year. Many times this might be glossed over or maybe not talked about to the fullest extent. So if you feel like your student is in need of extended school year during your annual IEP meeting or any IEP meeting that you call in between those annual meetings, you should ask to consider extended school year. If your IEP team does not talk about it, you can ask them to go back and talk about that because you feel like that is something that as a parent, you want to participate in that discussion.
I have an additional question. Is there a date or a time frame in which the team should be discussing this or come to an agreement on the ESY in particular with summer coming up?
So there isn't, because remember, extended school year does not have to happen over summer break. ESY services can happen at any point in time. So it's required to be discussed at each annual IEP team meeting. However, many teams might say during your annual IEP meeting, we don't have enough data right now to say, hey, over the summer, since that is typically the longest break, we may see some retention and recoupment issues. So we're going to reconvene usually around February, March, or April to start discussing if these are things or there are patterns that we need to look at more specifically. But there isn't anything in the law that says you have to do this by this time every year. It says that you must discuss it annually. Did I get that answered?
Yes, thank you. It looks like we had another question come in. Hypothetically, if a child is struggling with reading comprehension, would it be best to schedule an IEP meeting to discuss ESY to assist in preventing regression?
Absolutely. So you may want to discuss reading comprehension, or you may want to just discuss generally the supports and services that are written into the IEP to support, hopefully, a reading comprehension goal. All right, well, I'll talk a little bit more and see if anyone else has any more questions. But like I said, I know I've shared a lot of information with you. So on the screen right now, you should see my information, Amy Rhone, and my assistant director's information, Chris Elmshauser, as well as our website at the Office of Special Education, education.ne.gov/SPED. So please reach out to us if you have any questions. As we are not able to answer specific student-related questions on this webinar, we would be able to help and support you individually if you feel like your issues may need some more individualized attention. And I think I saw one come in. Did I?
Yep. So it's it is not okay for a school to offer the same amount of ESY hours for each student.
Correct. So ESY must be determined individually for each individual student. One of the things that we see happen a lot is schools will have summer programs specific to students with disabilities. It's quite possible that those summer programs might meet a group of students' needs. However, those individual supports that are needed for that individual student have to be met through whatever program is being offered and must be discussed individually. So they can't just offer a blanket, we have a summer school program that will meet the ESY requirements for students A, B, and C. It has to be a very individualized determination. And I saw, can you request an IEP meeting at any time? The answer is absolutely. So there's a legal requirement per the IDEA that you must have an annual meeting. And every 3 years, you must consider reevaluation, or at least data that might support the need for a reevaluation or not. But you can, as a parent, request an IEP meeting at any point in time. Can they do that for compensatory education? Provide summer school to fit the need for compensatory education. So the answer is more complicated than just yes or no. Again, you as an IEP team would need to meet to determine that A, compensatory education is needed, and B, that can be provided during a summer school opportunity. So the short answer is yes, if it's determined that the summer school program will meet the needs of that individual student as makeup or compensatory education time that was lost for that individual student. Is there one more question and answer?
Yes, we had one more come in. What would happen if a school is doing this and calling it ESY and there is no PT, OT, or speech offered?
So just because speech, PT, and OT is offered during the school year, it may not be determined for an individual student that those are the skills or instruction that won't be retained or recouped. So again, you have to make an individualized determination. So if as a team you decide the summer school program will meet the needs of the ESY supports that individual student needs, but then you also determine this student is going to lose some skills that have been taught during speech and language, then you may decide as a team, we're also then going to provide speech and language support once a week for 30 minutes or whatever that individual student might need, in addition to the summer program that is being offered. Or it might be that a summer program around speech and language is being offered, but your individual student is needing more support in math and occupational therapy. So that summer program might not fit the needs of your individual student. Again, that's why it has to be very individualized.
And then it looks like we have another one. Can you request a reevaluation if you have conflicting information between the school IEP and a psychologist evaluation?
So yes, you could request an IEP meeting to talk about the evaluation that was completed. If you don't agree as a parent with the evaluation that has led to the development of the IEP, based on an outside or a private psychological evaluation, you can always ask for an IEE or an individualized education evaluation. You must, however, show that, and within the IEE, that is needed to support the development of the supports and services and goals that are written into the IEP. If a school district does not agree with an IEE or providing an individualized education evaluation, they will then be required to file a due process against the parent, and a hearing officer will have to make that determination.
I think that's it for questions.
All right. Well, thank you all so much for letting me join you. And please reach out if I caused confusion or if I didn't address something that you really have a question about. Please reach out to me.